Hello and welcome to this mini course, IP Strategy 101 for SMEs and Startups. My name is Maria Boicova-Wynants, an IP lawyer and IP strategy consultant in love with IP since 2004. In the upcoming lectures, I will unpack IP and IP strategy in simple terms, without legalese, and in total under 100 minutes. This lecture series is available in audio and video format. Video format contains easy to follow visuals, so if you're listening to this as a podcast, head to my YouTube channel for a video version. This is lecture number 5, where you will learn if and how you can protect your ideas and how you can patent your inventions. If you missed the first 4 lectures, I will include the links in the description. Are you ready? Let's go. So, today we will talk about ideas and about inventions. And I will start with the first one, ideas. This is a frequent question I get. How can I protect my idea? Well, you can't. Intellectual property laws typically don't really swoop in to shield your ideas in their abstract form. So ideas, those ethereal sparks of genius, they're not eligible for protection. But wait, there's a twist. While ideas themselves may roam free, it's all about how you breathe life into them, how you nurture and wield them into the world of business. This is what truly counts. So, what exactly do intellectual property laws safeguard in this case? Drum roll, please. It's the expressions of ideas. When your idea takes on a tangible form, a book, music, software, or a nifty invention, that's when the magic happens. Copyrights, patents, or other IP rights, they step in to play guardian. Put differently, it's all about protecting the manifestation, not the initial spark. Here's a little example to drive the point home. Imagine that you've got a dream, a vision of launching an online heaven for watch enthusiasts, a web shop showcasing an array of stunning and unique watch straps. The mere idea of a watch strap emporium won't be cloaked in legal armor. On the other hand, those dazzling, one of a kind designs that you conjured up for those straps, they could very well be unicorns in a legal tuxedo, eligible for protection. But the enchantment also doesn't stop there. Imagine your website, if it's, of course, not just a cookie cutter template, but a masterpiece of graphic design. Also, this is potential protection waiting to be unleashed. And of course, let's not overlook the heroes of your brand, the name and the logo. They are undoubtedly the shiny armor ready to fend off any copycat invaders. Now, imagine if your idea is not just skin deep, but harbors juicy details guarded under lock and key, with economic value to boot. Guess what? These secrets of yours might just qualify for the exclusive club of trade secret protection. So you see, as the story unfolds, while the idea itself, that overarching concept of the shop, cannot be protected, there's a wealth of your idea that can be shielded. Hence, it is with the details and designs where the true magic of safeguarding your inventive treasures lies. The point to remember is thus this: while intellectual property laws may not protect your ideas directly, they still are the trusty guardians of the tangible fruits of your creativity and of your innovation journey, the expressions of your ideas. Now that we're clear about the ideas, let's talk about the inventions. Can I patent this? That's another frequent question that I'm asked. Let's set the record straight. The first question to ask yourself is not should you patent this? Strategic thinking about IP doesn't kick off with a patent. Nope, that's the wrong starting point. Patenting must be about aligning with your business vision, not just ticking off a legal checkbox. Thus, it all begins with, as said multiple times already, with a deep dive into your business model. Who you are, who your customers are, what makes your industry tick. These points are fundamental before there could be any discussions about patenting or not patenting. Strategic IP thinking is about deciphering the role of IP in your business. It's not a game of can we patent this or not. It's about what truly adds value to your business. Here's the golden rule. Just because you can patent something doesn't mean you should. And this applies, in fact, to all IP rights, not only to patents, but also to trademarks and to designs, like I'll be talking about later. It's about finding the perfect fit, not shoehorning in something that doesn't belong. Keep this mantra close. IP rights must make sense. I repeat this one ceaselessly. Tossing cash into legal documents without syncing up with your business model is like chasing shadows in the dark. On the other hand, crafting a savvy IP strategy can be a true game changer, but of course, only if done right. So, kick things off by defining your market stance and unraveling your product's customer's allure. It's all about your business, your model, your market, and of course, your competitors and your customers. What makes your product shine? Which features matter most to your customers? Can you carve out a unique space for yourself in the market? Answering these questions with precision aligns your IP strategy with your business aspirations. So, what's the key to the magic, you might wonder? Well, dive deep into your business to unveil the exact IP rights you need. This is where the magic lies. And if your business model actually warrants a patent, here is what you need to know. A patent protects a technical solution to a technical problem. It can thus be a technical product or a process. To get a patent, your invention needs to be new, have an inventive step, so be better in some way than whatever was there before, and be useful in some practical way. This could be anything from a high tech gadget to a clever improvement on a simple item, like be it a foldable chair or a sleeping bag, doesn't matter. When you have a patent, it means you are the only one who can make, sell, or use your invention for a while, usually up to 20 years, subject to payment of annuity fees every year to keep it alive. But, and here's an important point to stress, you don't really need a patent to be able to make, sell, or use your invention. You need a patent to make sure you're the only one. An important detail: the date you apply for the patent matters a lot. It decides who gets a patent if more than one person applies for the same thing. And another important detail: be very careful with the already mentioned novelty requirement. Novelty can very easily be compromised. So, if you intend to apply for a patent, be very careful with what you reveal about your invention prior to filing a patent application. For example, if you have disclosed your invention to someone not under the non disclosure agreement prior to filing your application, you will compromise the novelty and will not be able to secure a patent for your invention. In other words, stay vigilant. When you apply for a patent, you will need to fill out some forms and give a detailed description of your invention, together with specific claims. This description has to be clear enough that someone who knows about that kind of stuff can understand it and actually make your invention. This is the condition. You also need to write down exactly what parts of your invention you want to protect. They're called claims. Getting this part right is super important because it essentially determines how much your patent covers. And no, you cannot claim it all. It's always about the specific part. So if you mess up on any of this, you might end up with a weak patent that doesn't really protect the invention like you want it to. That's why it's actually smart to get help from a patent attorney who knows all the ins and outs of this process. However, at this point, I want to stress especially before you engage a patent attorney, you must have clarity on your current and future business model and the intended customer benefit that you actually want to protect by this patent. Think in terms of use cases. Brainstorm the alternative implementations. Namely, think about how your competitors will try to offer the same customer benefit. Because trust me, they will. And how you can use a patent to prevent them from doing that. In other words, while the technical process of preparing the patent application is something that you better outsource, the strategic part, which comes before all of this, is absolutely yours to tackle. And by the way, talking about strategy, patenting something is not the only way to act. You can also explicitly reveal your invention to the public, opting for a so called defensive publication. A defensive publication involves publicly disclosing your invention or innovation without seeking patent protection. You might wonder, why would you do that? You see, by sharing detailed information about your creation, you establish prior art, making it freely accessible to the public and preventing others from obtaining a patent for the same idea. So, this is not about claiming the rights for yourself, it's making sure that no one else claims these rights for themselves. So, defensive publications can, in fact, serve as a cost effective alternative to patents in some cases, and particularly for inventions that may not be commercially viable or that you wish to keep in the public domain. Opting for a defensive publication enhances your freedom to operate, and this one is an important one. This proactive approach safeguards your ability to use, develop, and commercialize your invention without the threat of potential legal challenges or constraints imposed by patents held by others. In essence, defensive publication empowers you to navigate the market with greater freedom and confidence, knowing that your path to innovation remains unobstructed. Put differently, a defensive publication can be a very interesting option to pursue, definitely something to consider. If that, of course, fits with your business goals, because the business always comes first. This only once again illustrates the point that I made in the very beginning of this lecture. It all starts with your business. Before I conclude, I would still like to say some words about open source and patents. Open source is great, but open source is not without limitations. It does not mean that you can freely do with it whatever you feel like. Open source means something that anyone can change and share because its design is available to the public. Most open source software is free, but not all of it. And besides, some open source licenses have rules that are, in fact, too strict to be considered free. A point to remember is that when something is open source, it's not like it's in a public domain or it's a free knowledge. Usually, there still is an owner who gives it to the public, often for free, but under a license. And this license has certain conditions. It gives users certain rights, and most importantly, it gives users also the responsibilities. Frequently, open source can contaminate your IP rights and even undermine your business model. Therefore, when engaging with open source, it's absolutely crucial to be mindful of potential pitfalls from an IP perspective. One common risk here is inadvertently incorporating code or components that are subject to conflicting licenses, leading to legal entanglements and disputes over ownership and usage rights. Additionally, relying heavily on open source without comprehensive due diligence can result in unknowingly adopting code that infringes upon existing patents or copyrights, exposing the organization to costly litigation and reputational damage. Failure to establish clear boundaries between open source and proprietary assets may also lead to contamination of IP rights, undermining the exclusivity and value of proprietary innovations. Moreover, inadequate documentation and oversight of open source usage within the organization can hinder traceability and compliance with licensing obligations. And this all potentially results in non-compliance penalties and loss of trust among stakeholders. So, overlooking the potential for third party contributions to open source projects to introduce vulnerabilities or malicious code, this also poses security risks and can compromise the integrity of proprietary systems and data. So, you see, navigating the complexities of open source requires really vigilance and proactive management of IP risks to be sure that you are safeguarded against potential legal, financial, and reputational repercussions. How to find this balance between using open source and protecting your IP, in particular, patenting your inventions? While there are, of course, many aspects to bear in mind, here are the most important considerations. It is a balancing act. Yes, you can have the best of both worlds, absolutely, but keep your ideas safe while diving into open source by setting clear boundaries between what's yours and what's open. Think them through, define them, write down your definition, and make sure that all stakeholders are aware of the rules of the game. Choose wisely. When it comes to licenses, it's like picking your favorite playlist. Choose licenses that vibe with your goals, with your business goals. This ensures a smooth dance between open source and your proprietary gems. Team harmony is, of course, key. It's the secret sauce. Make sure that your team is on the same page. Educate them about the do's and don'ts of open source and proprietary zones. You cannot control it all by yourself, so team harmony is an absolute key. Separate but together. Think of it like hosting a potluck dinner. Open source brings its dish, and your proprietary stuff has its own table. Keep them separate, and everyone gets a taste without compromising the secret sauce. Embrace open source, but mind the terms. Open source is like a bustling marketplace of ideas. Enjoy it. But, like in any market, be aware of the terms and conditions. Clear licensing terms and restrictions are your compass. But most importantly, actually do read those terms and conditions always. To wrap it all up, finding the perfect harmony between leveraging open source and safeguarding your intellectual property requires a delicate dance. Remember, it's all about striking the right balance to enjoy the benefits of open source while at the same time protecting your valuable intellectual assets. That's it from me for today. In the next lecture, I will be talking about trademarks. This course is created based on the book Intellectual Property, The Key to Your Competitive Advantage, and is recorded by its author Maria Boicova-Wynants in 2024. This was the fifth lecture of the lecture series Intellectual Property Strategy without legalese and in under 100 minutes. Thank you very much for listening and see you at the next episode.